Hi guys, let's talk about California law regarding recording without the other person's consent. So California is two people recording statutory requirement to consent to any recording. For example, if there is an expectation of privacy, let's say in a bedroom, husband and wife are, or husband, wife and wife, sitting and talking, and one spouse is recording the other and then uses it in court to prove a point of some sort, that recording, the opposing side will object based on no consent. And there are exceptions when it can be used. It is very typical in domestic violence restraining order for the victim of domestic violence introduce evidence such as a video recording of the other spouse's actions that could be considered abuse. And it could be also a situation where one spouse is recording how the other spouse is acting in an abusive way towards their minor child. So let's pack it all up. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. First, Penal Code Section 632 states that if someone has expectation of privacy, no recording is allowed without consent. In a situation where, let's say, one spouse is abusing a child and the other spouse is standing in the doorways and is recording it for the purposes of documenting child abuse or domestic abuse, first of all, doorway could be construed as not a private area because anyone can walk in through the doorway, even if it's your personal home. So the expectation of privacy is in a closed realm where you don't expect someone to come in. So, second argument, if the child is loud, screaming,
"Help me,"
or "You're hurting me, let me go," then that can be reasonably be overheard by someone else, not the abuser, but the other person. And then that person would come in and rescue the child. So then it's not confidential. There is no expectation of privacy if it's loud, if it's not in a secluded area where the door is open. So that's one portion of that discussion. The second portion, if the court says, no, you can expect privacy even if you're in the home, even in the doorway, and even if the child is loud, or even if abuse is happening, I don't know. Let's say this is all confidential. I'm not going to even watch the video because I don't want to ring the bell, watch the video that, for example, I watched the video and I found there was no abuse, but it's so disturbing that now I cannot rewind and unsee what I've seen. So then we have exceptions. Exceptions are when consent is not required if the other person who is filming it is expecting that there will be domestic violence or any crime be happening. For example, what would be the situation? Each time one spouse gets into a fight with the other spouse starts yelling and pounding on the table and hitting walls, accusing or saying things that are threatening. I would kill you, I would bury you, things like that. So the first exception is Penal Code Section 633.5. And it says, so the confidentiality can be overturned by no consent required if the person who is recording expecting a crime. And a crime could be DV, domestic violence, or child abuse. What if there is potential abuse but not clear? So the judge would need to see and determine whether the video has the abuse. So the recorder is recording without the other person's consent, but then the other person is abusing a child. Can the recorder, because you have two people consent, so the person who is abusing doesn't give consent, obviously, because they don't want the judge to see the video, but the child, could the child give consent while screaming, "Help me," well, there is a theory and there is a case called Trevor, Trever, 2017 California case of appeal, where the court determined that the child cannot give consent, but the parent can get vicariously consent from the child because the child is asking for help. And in that case, it was pretty extreme. The child was sexually molested by another child, and mother left her phone and recorded everything. And whoever molested the child who molested, their lawyer said, well, no, you cannot, that nobody gave consent here. So, and the child who is being recorded didn't give consent because the child couldn't give consent. It was a complete infant. So then it went to appeal, and the Court of Appeal said, well, it's called vicarious consent. A parent of an abused child can give consent on behalf of the child. Second exception is Penal Code Section 633.6, and it says recording targeted for court's use, intent to preserve evidence for DV. So if someone is recording, knowing that they're going to file a DV case, and then whether they use it, whether they file a DV, that is not required. The intent to document for DV purposes is what's required. So there's another case that says the person who recorded it for DV does not need to file actual DV. Why is it important? Well, for example, you don't need to file a DV in order to ask the judge for sole custody if there is domestic violence happened within the last 5 years. So the code section 3044 says any party in custody proceedings, and I'm paraphrasing, could, upon request, ask for sole custody, and the court will determine sole custody presumption if in the last 5 years it is determined that abuse has happened. So at any point in time in custody proceedings, abuse can be raised as an issue without having to file for domestic violence restraining order. That is what this code section is inviting to do. It's not always necessary to say, I need no contact, this person needs to stay away from me. Some people just decide to have sole legal physical custody based on the other parent committing domestic violence without filing for domestic violence. Possible, all possible. And the final exception is public policy. Someone who is committing an act of crime cannot expect privacy, period. That's just wrong. So that's that. I hope this was helpful, and I'll see you in my next video. Bye!